this. This is a statute that really targets the construction industry. It applies to everyone who touches buildings or touches land, and it really has its underpinnings in a perception about the construction industry that I don't think is founded, but you can even find it in the statute. It says that they're targeting what they see to be unscrupulous employers and employers who operate in the underground economy, and that's actually right in the beginning of the statute. So obviously there's some perceptions that the industry as a whole have been taking advantage of the independent contractor status of people to deny them certain benefits or to avoid certain labor laws. And I think that has the underpinnings of the statute we have in front of us. So really, what is the Fair Play Act? What it's done is it actually is a statute that has made a different set of rules for contractors in measuring whether or not the subs or individuals that they use are actually independent contractors to whom they don't have to have workers' comp coverage, unemployment, pay overtime, really whether or not those subcontractors are independent businesses. And it sets a much higher bar for you than in the general public or general business community at large. You really have now a statutory requirement that you have to satisfy a whole litany of tests, and all those tests must be met for someone to be considered, or for a business even to be considered, an independent contractor. In addition, to motivate contractors to comply with this, they've actually put in some very substantial penalties that are in addition, above and beyond those that you can already face for misclassifying businesses or individuals as independent contractors. And we'll get to that in a little while. But they can be substantial, and they can include, for those of you that work on public projects, debarment. Now, and the last thing that it also does is that it has a retaliation provision. So if one of your subcontractors or even one of your employees, or if you have a union there and they incite some of your employees to complain about it, which happens more often than not, those people are protected from retaliation, so that if someone says, hey, those people aren't subcontractors, they actually should be employees, you should be covering them, and you fire that person or take any other action against them, you can be liable. Now, I mentioned the penalties, and they can be substantial. Before we get into actual requirements of the law or what standards they put you under, you should know that violating this can lead to penalties of up to, for a first offense, $2,500 per employee per incident. So for every person that's considered a subcontractor, even if you employ them on several different jobs, you can be penalized up to $2,500 per worker per each of those jobs, it seems. And if you're a repeat offender, that can go up to $5,000 per worker per job. So say you have 20 subcontractors, that adds up very quickly. There's also a posting requirement that I'm not going to spend a lot of time on today, but essentially there's a posting that you're going to have to put up that the Department of Labor needs to get ready within 30 days of the effective date of this law. If that's not posted at every job site, you can have a penalty of up to $1,500 for first-time offenders and up to $5,000 for repeat offenders. Similarly, criminal penalties come with this, which are possible. And it's a misdemeanor, which can result in 30 days for a first offense or 60 days for a second offense of imprisonment. And for first offenders, you can also have a $25,000 fine, and repeat offenders can get a $50,000 fine. Also, there's debarment, as I mentioned before, which can bar you from public works projects for up to 1 year for a first-time offender and 5 years for a second-time offender. And this really applies to not only the business itself, but anybody who is an officer of the company can be held personally liable under this law, as well as any owners who own at least 10% of the company, regardless of the form of the company. Also, if you have affiliates that have substantial common ownership, those entities, say you closed one business and you had another business open, they could go after that business a year later and say, hey, you were affiliated with the entity that engaged in the violations, and you're liable for the penalties under this law. And again, these penalties are in addition to fines for workers' comp violations, because if you have an independent contractor and they aren't covered and they find they're an employee under the statute, you get workers' comp fines, unemployment fines, overtime issues. Obviously, if they're prevailing wage issues, they can come after you for that as well. Now, really, what does this law mean? What have they done here? Essentially, what they've done is they've set up for the construction industry a presumption that everybody who works for you on a job is your employee, and that's presumed. So if you're the GC on a commercial project or even on a residential project, and you bring people in as plumbers, electricians, etc., and they're working on that site, the initial presumption of anyone coming on there from the government now is that they're your employee, and you have to rebut that presumption. And it used to be, when the government came calling, that if they had their own corporation, had set up as a trade, Joe's Plumbers Incorporated, was not going to be considered your employee, and that was a pretty easy way to get out of the issue of whether or not you had actual independent contractors working for you. That's not sufficient anymore. If someone has their own business, it doesn't necessarily mean that you're going to be insulated from somebody coming on your job and saying, hey, that person's actually an employee, and you're going to be fined under the statute. Same thing, even if your subcontractor pays workers' comp taxes, unemployment taxes, income tax on its business, and even employment taxes on the people it employs, that's not going to be sufficient by itself. Really, they've set up a standard where you have to meet every single test of their independent contractor test in order to have these individuals or companies considered to be independent contractors rather than employees. Now, that varies from what used to be the case, and I think we're all familiar with what the old tests used to be. They varied per statute, but in general, it was a balancing test, and it was a balancing of how much real control did you exert over the individual, and what was their economic independence from you. Essentially, were you the only source of their income, or were they so intertwined with your business that they really weren't a separate entity? Was it the same electrician on every single one of your jobs, and the only work he got all year was from you? Then they may look at that person as being an employee versus an independent contractor. Again, it was a balancing, so you could meet just a few of the factors and still have someone be an independent contractor. And also, it was a more reasonable test, and reasonable being that they would look at everything. They look at the whole scenario, even if it wasn't someone who was bright line on, okay, they meet X, Y, and Z factor. If in the reality of the situation, they had their own business on the side, they were filing their taxes, they were paying workers' comp and unemployment, generally the government was a lot more lenient on you than they're going to be going forward. The traditional test focused on a lot of factors, and I'm not going to really spend a lot of time on this, although it's a few slides. But it focused on pretty much, where the work was being done, who was paying for the tools, who was setting the hours of work and how the tasks were going to be done, whether or not somebody was holding themselves out to the general public as an independent business or providing services to several different businesses, who was actually training its workers or providing the training, whether or not you had a continuing relationship, how the person was paid by you. Was it a project? Did you get a quote from the subcontractor saying, hey, it's going to cost $30,000 for this job, or was it something where he was charging you by the hour, which would make it more likely he was an employee? Again, the skill level, skilled trades were seen as more likely to be independent contractors as opposed to, I know a lot of people use cleaning crews, and that's essentially an area where I've seen a lot of problems in your industry where even under these tests, they were found to be employees, because that's not a skilled job. It's not the same as having someone who's doing the roofing on a job or something like that. It's people that are just showing up and cleaning up. So that's another factor that was in the old test. Also, obviously a written agreement carried a lot of weight. If you had a services agreement with your independent contractor, they were paying their own taxes. That was all clear in the agreement itself. That would help substantially. Again, if it was a separate business, who was responsible for the profit or loss, and also whether or not the work they were doing, how separate it was from your business. Now, the reason I actually went through these is that you're going to see, as we go further here in the presentation, that what they've actually done is use a lot of those standards to create the new test, but what they've done essentially is not made it a balancing. They've essentially said you must meet every single one of the factors we set forward, and if one of them is missing, then the person is going to be an employee. And so I think that's the major deviation from the prior test. But it's good to understand what the old tests were, because a lot of the things that you're going to have to comply with now are from those standards, so they're not going to be unfamiliar to you.